If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more.
So I, like many of you, have been captivated by the Idaho4 case since November 13th, 2022. And in the 6-week manhunt for justice that ensued after the crime, we were even more shocked when we saw that the person accused of this crime,
a criminology student, a teacher's assistant, a PhD criminology student who studied the very extreme offenders, he was now accused of being.
I do feel that what I heard in yesterday's hearing has blown this case wide open, at least in my eyes. I heard two things I really want to go over in this video, and those two things would be the eyewitness testimony and the two sources of unknown male DNA. So let's start with the two unknown sources of male DNA.
So as of this moment, law enforcement has tied Bryan Kohberger to the scene of the crime with a piece of touch transfer DNA that was found
on the buckle snap of the K-bar knife sheath that was left at the scene. Now, we had heard rumors that there were other unknown male DNA. Now, we didn't know exactly what this DNA was, if it was some sort of, like if it was blood, if it was body fluid, if it was touch transfer. But in these open hearings, we found out
not only was this unidentified DNA, blood DNA, but it was found in two very odd places, one being in a handprint on a banister, and the other one being outside in a glove.
If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more. Maybe
I'm just not sure why it matters for probable cause, but I think we're talking over each other, so I'll let you just go on.
Okay. I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
What bugs me the most about the unknown male DNA is if you have unknown male DNA, why wouldn't you work up a genetic genealogy family tree the same way you did for the touch transfer DNA?
Because at the end of the day, every concerned citizen should wonder,
is our community safe? Is our community safe?
Because at the end of the day, the average citizen has to wonder, are there other people responsible for this crime out there?
Extreme offenders out there. And at what the hired private investigator for the defense, Richard Batanti, had said back in 2023. He said that BF, the first floor roommate, had information that was material and exculpatory to Bryan Kohberger. I'm going to read you this community post.
I'm quoting from what another poster said here about what Stacey Chapin said in a November 17th interview. Apparently, she got this information from one of the young guys who was called to the house before any LE arrived. She said, BF said she heard loud male voices, Ethan's being one. There was a lot of yelling with guys. Murphy was heard barking. Sounds like furniture getting knocked around. And then a loud thud. After the thud, it appeared to be silent. BF thought it was drunk frat guys arguing and just roughhousing, but she did not say she was scared. That interview, that has since been edited to remove that particular segment, no mention of anything like this in the PCA.
Now, we don't have this as an official source, but this comes from one of the victim's parents. So it's a pretty reliable source. But then when you hear the testimony that was brought forth yesterday regarding DM, the second floor roommate, things begin to look a little bit differently.
So we're going to listen to this soundbite of Ann Taylor in open court, and then we're going to talk about it.
What she stated sounded like one of the victims playing with the dog, which was on the 3rd floor. A short time later, she thought she heard one of the victims say something. That caveat, she thought she heard, is a problem. That's not at all what was said. This person was interviewed shortly after 911 was called in the afternoon of November 13th, 2022. And she was sure, I'm at Defendant's Exhibit 8A, page 281, lines 4 through 10, when this witness was sure that she heard this particular victim go up the stairs, and then come running back down the stairs. That is not what's contained in this affidavit at all. That is repeated during this same interview a couple of different times at page 287. It's also repeated in a subsequent interview that same day. This is Defendant's Exhibit 8B. That's at page 313 and again at 320. That is important because that's misleading to the judge. That waters down what was said, and that matters in the probable cause affidavit, because the officers, when they wrote this, knew that wasn't the case. They knew this particular person that DM said was upright and running down the stairs, that's not what happened. That person was killed in the bed and never left the bed. And so the officers water that down because they know that fact is wrong, but they don't tell the magistrate that. They also don't tell the magistrate that this witness has claimed memory problems, that this witness has claimed that she's not sure what she heard or saw was real, or whether it was at a dream, and that is contained in Defendant's 8C, and that's going to be beginning at page 396, 398, 399, 403. There's further statements from that witness in that police interview that said that she had too much to drink and couldn't remember. None of that is given to the magistrate. That is information that's withheld. That's credibility of the person telling law enforcement these things, and the magistrate had a right to know that whatever is laid out in here isn't exactly the way it was. That person had credibility issues, and she said things that were just absolutely untrue and couldn't have been true. Law enforcement knew that. That was intentionally withheld from the magistrate. That matters when we're talking about credibility and sets this whole thing into motion.
Okay, so a couple of things. Number one, obviously the police found that some of her story was viable. Now, whether that was because they backed it up through forensics in the phones, maybe the roommates were texting each other. We've heard rumors of that before. Maybe she was texting other people in the house. I don't know. But parts of that story were corroborated enough for them to put it in the PCA. As someone who covers the case, I am completely fascinated with other things that DM had to say. DM mentioned a victim running up and down the stairs. I mean, it's very hard for me to completely dismiss that. Maybe she didn't actually see that particular victim, but did she see something? Did she see something going up and down the stairs? I don't know, but I'd really like to know what you think. I mean, for me, this is just one of the most explosive parts of this case, and I just really want to know what my viewers think about this. Watching a lot of the arguments today. In particularly, I paid close attention to Mowry and Payne on the stand. And one of the things that they brought up were the search warrants and the dates. So I want to play you this kind of lost clip that was on the news right after Brian's apprehension. This little soundbite I'm going to show you early on talks about one of the Pennsylvania attorneys saying that they had been surveying Brian Koberger for weeks prior to his arrest. Well, the search warrant only goes back 10 days. I'm not contradicting that. So he could have just misspoke.
And police found him.
Mr. Koberger, as with any other criminal defendant, is presumed innocent unless and until proven guilty in a court of law. So that remains the case. But certainly for the investigation and the interest of the investigators in building the case, layer by layer, that was a significant find.
This search warrant confirms Brian Koberger was under police surveillance for several weeks before he was arrested.
So he could have just misspoke. But I want to remind you of one other thing we learned on the stand today that Corporal Payne said. They were out there working with investigators prior to Brian Koberger's arrest. One of the victim's parents said that they were surveying Brian on December 13th. I still want to leave a little window open as we're talking about the what I've dubbed the baby Franks. And the reason I'm bringing this up is because Detective Mowry said on the stand today, he was out there prior to Brian's investigation working with law enforcement. And I just wonder what this gentleman had heard, because he could have just misspoke, or maybe they were looking at Brian a couple weeks before that search. And maybe they found Brian some other way than the investigative genetic genealogy. And when it boils down to it, that's about investigator prosecutorial misconduct. And I just wonder, were they going over the search warrants today, triggering that Franks hearing? I don't know what it all means. I thought I'd bring it to my audience so you can do whatever you need to do with it. So if you've made it this far, into this video, I just really appreciate your viewership. I just want you to know I'm so grateful for you to sit down and listen to what I had to say. I would be honored if you considered subscribing to my channel. I try to put out content like this daily, and I hope you have an amazing weekend. I will give you updates as they come to me. Peace.